It's Nolan.
Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show.
It's coming right back. In the city, just a couple niggas with me, cause I know I gotta watch my back. And I'ma be the realest when the dark falls down. And I'ma still be standing when the sky fall out. They say it's gang till it's time to roll out. But when them things bang with them niggas at now.
Yo, I had niggas turn their back cause I ain't blow up quick enough. Now the song's picking up, I see they started moving sus. Every other day somebody tryna pick in my brain. I got consulting fees for that, my boy. Shit done changed, I need at least $1 million plus a Richard Millie. I don't think they feel me, y'all. This game I drop, I'm on my gilly. Tell me what the dilly, stupid, silly fuck. My girl exclusively in trucks. You sending texts, but I no check. We make the message self-destruct. Ain't even chasing women. I just state my business, getting straight to chicken. Seen too many niggas lose their freedom for they code to finish. Shit is switching. I've been peeping all this from afar. 30 miles from out the city, I just show up to do my job, nigga. Ever since COVID, I've been laying on my lowest. Started weighing pros and cons and saw this shit was all bogus. I'm just exchanging value. Speak my truth and I just pray it matters. Can't make excuses if you ain't actively changing patterns.
What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there. In this particular video, we're going to be addressing Jay-Z, Alex Spiro, and co. Firing back at Tony Buzbee. This is as it pertains to the federal lawsuit. This is as it pertains to the big case with the essay allegations on Jay-Z and Diddy. The latest update in that Texas lawsuit that Buzbee has on Jay-Z, it looks like Roc Nation and his league of attorneys are also filing a motion for that to be taken out of Texas jurisdiction and to be taken to a federal judge. So they're not backing down. They want to take this to the big stage. Okay. But more information on that will be disseminated at a later time on whether or not it gets moved. But today on this video, we're talking about Jay-Z's response, right? Because about a week or so ago, Jay-Z filed a motion to the judge stating that that Tony Buzbee should be fined and sanctioned for irresponsible activity, not properly vetting his client, and basically just a mishandling of justice, right? For extortion. Tony Buzbee replied. He gave us all these reasons as to why he felt that he should not be sanctioned, right? And now Jay-Z and Alex Spiro, Quinn Emanuel, etc., have issued another response through the courts. Okay, so let's go ahead and pull this up. Let's go through it. I don't have like a super amount of time because I'm trying to get me a nap in, you know what I'm saying, before my son come home. So we got to get this content in and then move on. Okay, so let's get to it. So they state, preliminary statement, a principal attorney, when confronted with factual inconsistencies that cast grave doubt on horrific allegations and reveal the inadequacy of any pre-filing inquiry, would reconsider the lawsuit, right? So they're saying anybody worth a grain of salt would have been reconsidered this lawsuit and probably would have withdrawn it, right? So they come in swinging. Instead, plaintiff's lead attorney, Anthony Buzbee, tried to gloss over them. Initially, he deflected, saying plaintiff's case was referred to him by another, we talked about that, who vetted it prior to sending it to him, and that his firm would continue to vet her claims and collect corroborating data. That's literally in the paper trail that the judge has where they stated that. Okay. And it's in the article that they spoke to NBC. They say now he concedes that he did not even meet with plaintiff before signing his name to the complaint docket number 76 and fails to identify any evidence that corroborates anything his client alleged. Meanwhile, he has litigated this matter for 3 months without seeking admission to this court or explaining this failure, including throughout earlier cases he filed in this court. Docket number 76-1. Mr. Buzbee's studied detachment from the mandatory diligence and admission procedures contrasts starkly with his exertions outside of court. There is no denying that he has, in press conferences, social media, and media interviews, systematically weaponized the allegations of his still anonymous plaintiff to damage Mr. Carter's reputation. Mr. Buzbee is conducting himself as he is knowing that his in-court submissions may be cloaked in immunity. Mr. Carter seeks only to hold Mr. Buzbee to the ethical standards that constrain any responsible attorney who would solemnly sign his name to allegations in court. Without such guardrails on litigation, there is obvious worrisome risk. Someone in Mr. Buzbee's position could level reputation-destroying allegations indiscriminately in court with an eye towards leveraging them in sensationalist fashion outside of court without ever properly inquiring into their truth or facing accountability. That concern looms large here. Mr. Carter has identified factual inconsistencies demonstrating the allegations in the FAC were false or highly suspect. These inconsistencies undermine nearly every step in plaintiff's narrative: her arrival and whereabouts at the VMAs, her interaction with celebrities, the purported residence, the timeline, and how she got home. Plaintiff's opposition does not meaningfully engage these demonstrated inconsistencies. Notably, for the one issue she seeks to rebut, whether Mr. Combs owned a home fitting the FAC's description, plaintiff's arguments only confirm the errors. All told, plaintiff lacks any satisfying answer to the identified discrepancies. Right. And I said it the other day, if you're going to go off of the house that's in East Hampton, New York, that adds 3 more hours of travel time for everybody. Right. Because to get from Manhattan to where that house was, that's 3 hours, which means her dad would have had to travel 8 hours to retrieve her, 8 hours to get home. And they would have had to travel 3 hours from partying in New York City to get to this place and then have this after party. And then had this wild assault where all of this takes place with celebrities in attendance, an unnamed celebrity woman in attendance in the room, and unnamed celebrities that allegedly saw her, walk out half clothed to no one having any sort of reaction or anything, and no one seeing her walking down the street. Okay? But we'll continue with what's in the paperwork. All told, plaintiff lacks any satisfying answer to the identified discrepancies. It is now common ground that neither Mr. Buzbee nor any of his colleagues ever so much as asked the plaintiff's father whether he remembered playing his critical multi-hour role in the remarkable tale spun by the FAC. If they had, they would have learned what a curious NBC News reporter learned by posing that simple, easy question. He remembered no such events. Mr. Buzbee now suggests myriad ways that a rigorous investigation was performed by unnamed colleagues, but those efforts fail to satisfy his own Rule 11 obligation to conduct a reasonable inquiry, pre-filing into allegations that facially test the outer limits of credulity and indeed fly in the face of readily ascertained facts. Mr. Buzbee could not farm out to unspecified others his Rule 11 obligations, which attach personally to him as the signer. Right? So all these other people did all this work, but he's the one that signed on it, and now he wants to blame them. They are non-deligible. And having purportedly left the requisite vetting to others, Mr. Buzbee cannot now properly serve as the lone declarant attesting to matters that are outside his personal knowledge and known only to non-declarants who sit silent. Even assuming Mr. Buzbee had a reasonable basis initially to file the claim, post-filing exposure of substantial inaccuracies should have led him to withdraw it. He cannot continue post-complaint to whistle past demonstrated inaccuracies in plaintiff's allegations that are staring him in the face. Rule 11 sanctions are well warranted, and Mr. Buzbee's attempt to demand sanctions of his own is meritless, right? Because his rebuttal was that they should be paying him, not the other way around. The court should impose Rule 11 sanctions. An attorney who fails to investigate adequately before filing a complaint, particularly one alleging serious criminal conduct that will inevitably cause reputational harm, is subject to Rule 11 sanctions. Plaintiff is incorrect that the Rule 11 cannot be offended unless and until this court is convinced of the falsity of plaintiff's claim of SA. As multiple circuits agree, the question is not whether the claim itself was frivolous, but whether an adequate inquiry into the facts and the law was conducted. Mr. Buzbee signed a complaint whose allegations tested the outer bounds of credulity without conducting the barest of inquiries himself, then stood on them even after they were exposed to be false or inconsistent. Although Mr. Buzbee claims that rigorous due diligence pressure-tested plaintiff's allegations, he neither rebuts the inaccuracies Mr. Carter identified nor corroborates the FAC. Moreover, far from explaining these failings, he admits that he never even interviewed plaintiff before suing. Because Rule 11's defining purpose is to bring home to the individual signer his personal non-deligible responsibility, and the attendant obligation is not a team effort, but in the last analysis, yours alone, Mr. Buzbee's farm it all out approach cannot suffice. So he's basically trying to absolve himself of responsibility, although he has been her primary lead attorney. He just recently hired someone new to, be his counsel and hers. But up until this point, it was all on him. As to Mr. Buzbee's reliance on other lawyers and a retired police detective, which we still do not know who that is, to interview plaintiff and fact-check her account, none of those individuals has even been named, let alone produced as a declarant. So everybody that Buzbee is referring to are all anonymous. Nor does the opposition specify which aspects of plaintiff's complaint were fact-checked. Most strikingly, there is no claim that anyone asked the plaintiff's father, a key participant and ready interviewee, whether he remembered his chapter in the FAC's remarkable saga, to which the answer would have been no. More broadly, the FAC contains 9 key facts going to the core allegation of SA, 5 of which Mr. Carter's motion refutes or calls into serious question, and the rest of which were insusceptible to being fact-checked. So here are the 9 points. Allegation 1, friend drove plaintiff to NYC. They say that this was not fact-checked. When asked this person's identity, counsel identified a then 20-year-old, now deceased. Okay, not even a name, location, nothing. Right? We don't even know the gender of said friend. We just know they dead. Number 2, plaintiff watched VMAs on a Jumbotron. They've already fact-checked that as false. Limousine driver offered ride to after party. They say false. Party at large white residence with U-shaped driveway 20 minutes from Radio City. Clearly not 20 minutes away, especially if y'all talking about Diddy's East Hampton home, which was 3 hours away. They say false. Number 5, plaintiff signed what she now believes was an NDA. They say not fact-checked. Plaintiff lacks any such document. She has no copy of said NDA. Someone would need to produce it, right? If it was enacted. Number 6, plaintiff spoke with celebrities at party. They say false or highly suspect, of course, because the so-called celebrities that she spoke to, one wasn't even there. Fred Durst was there, but I'm quite sure Fred Durst can't even corroborate that he spoke to this young lady. And she was a young lady at the time. Number 7, plaintiff purportedly drugged, found room to lie down. They say cannot fact check. Plaintiff told no one for 24 years, did not undergo toxicology screening to even know if she was drugged. Interesting. Number 8, plaintiff ran out of house to closest gas station. They say cannot fact check. Plaintiff told no one for 24 years. Now claims to not know where the residence is located, let alone the gas station. Number 9, father picked plaintiff up just before dawn. False. And these are the main points of what even made their lawsuit. They say the only research Mr. Buzbee's firm apparently conducted was to confirm the purported close connection between Carter and Combs. That does nothing to substantiate the claim against Mr. Carter, and Mr. Buzbee does not identify anything actually corroborating the FAC or explain why rigorous due diligence somehow failed to turn up the factual defects NBC uncovered within days. No matter how adamant a plaintiff may be in alleging SA, the allegations are not self-corroborating. Responsible attorneys must conduct diligence and seek corroboration. Yet Mr. Buzbee's efforts all went elsewhere. He attests that Ava Law referred this case in early October before he filed it on October 20th, which is a very short period. In the less than 3 weeks between referral and filing, time he should have spent vetting this claim, he was on a press tour at multiple media outlets publicizing his campaign against Mr. Combs and alleged co-conspirators. Rather than contacting his client's father or running straightforward Google searches, Mr. Buzbee was litigating feverishly in the court of public opinion without regard for his obligations in court. The predictable upshot is that Mr. Buzbee got basic facts wrong, as the opposition only confirms. Damn, they going in. First, in responding to Mr. Carter's argument that public property records prove that Mr. Combs did not own a residence that fits the FAC's description in 2000, plaintiff wrongfully accuses Mr. Carter of misstating facts. Zeroing in on the 40 Hedges Drive residence, plaintiff argues repeatedly that Mr. Carter represented that Combs did not own this property until 2001, revealing his lawyer's own mistake concerning details on which they rely. Far from disputing that Mr. Combs owned that residence in 2000, the motion notes that he did. And we actually showed that paper trail of the properties he owned. They say he did own it. Mr. Combs sold it in 2001. Mr. Carter's point was and remains that neither this residence nor any other owned by Mr. Combs matches the description. To reiterate, while the specified residence is large and white, it does not have a gated U-shaped driveway and is located in East Hampton, a minimum 2-hour drive and over 100 miles from Manhattan. So I'll redact my 3 hour and go back to 2. So there's still an additional 2 hours, which means her father would have had to have driven 7 hours rather than 5 to pick her up and another 7 back. That's a total of 14 hours on the road in one night to pick up his autistic daughter, who was in a totally other place in a big city and then at a big home with grown men, celebrities, women, drinks, allegedly drugs. And this father never even bothered to ask what the fuck you are doing there. How did you get out the house? Who took you? Who did you know? And we're supposed to believe this. Rather than address these demonstrated disconnects, the opposition whistles past them while misreading the motion to manufacture a supposed gotcha. Second, Mr. Buzbee dismisses plaintiff's father's denial of picking her up that night, claiming the events occurred 24 years ago, so it's not surprising that he may not recall a specific drive to pick up his daughter. But it strains credulity that a father impelled to jump into his car in the middle of the night to undertake a minimum 10-hour round trip, and is really 14 if you're going off of that residence, trip to pick up his 13-year-old daughter at a random gas station, would forget the entire episode, and his denial was unequivocal. He said anything like this would definitely stick in my mind. Even by Mr. Buzbee's account, however, neither he nor any of his supposed diligence team bothered to check. Third, plaintiff dismisses her imagined conversation with Benji Madden as irrelevant simply because it was not discussed in the FAC. But the point is that plaintiff allegedly spoke with celebrities at the party, which would invite any reasonable attorney to ask who and then inquire accordingly. Especially in a case where so much hinges on a plaintiff's credibility, recollections about Mr. Madden's tattoo of the Last Supper are no triviality. Notably, it is undisputed that Mr. Madden was not in New York that night. Calling this a memory lapse cannot obscure counsel's lapses in investigating whether multi-decade-old recollections align with reality. Fourth, plaintiff dismisses photographs showing Mr. Carter at Lotus on the night in question, theorizing he could have partied at the residence after the nightclub. But that makes the timeline even more far-fetched, as Mr. Combs and Miss Lopez attended 2 nightclubs, Lotus and Twirl. The FAC requires that plaintiff arrived at the gas station after the alleged assault around 1:30 a.m., 5 hours before dawn, after fleeing the alleged party. Right? FAC says father arrived just before dawn. NBC Article 7, they say they lived in Rochester. Right? Dawn, 6:30 a.m. Given that the VMAs ended at 11:11 p.m. in approximately 2 hours, Mr. Combs would have had to have driven been driven to 2 different nightclubs, each at least 14 minutes from Radio City with zero traffic and 6 to 14 minutes from each other, which we know would have been heavy traffic at the time. Spent time at each club where he was photographed, been driven to the imaginary residence at least 20 minutes from Radio City, waited while his driver returned to Radio City to pick up plaintiff, a round trip of at least 40 minutes, waited more time while plaintiff mingled with celebrities and got intoxicated, and then assaulted plaintiff. Not to mention the fact, like, can we confirm that this so-called, we'll call her plaintiff, was she at the time still in a wheelchair, or was she able to walk at that time? Because that also would have something to do with, you know, how she's getting around too. Like, anyway, assuming arguendo that timeline can somehow be wrestled within the laws of physics, it cried out for reality testing. Fifth, plaintiff denies Mr. Carter's evidence that she could not possibly have watched the VMAs on a Jumbotron or spoken with limousine drivers, but plaintiff could not have watched on a Jumbotron in Times Square. Per the FAC, she was not in Times Square, but outside Radio City, which is nearly a mile away. And the denial of MTV's permit prevented it from being telecast in Times Square, so there was no Jumbotron, period. Nor could the limousines have been elsewhere because, per the FAC, she approached them while standing outside Radio City watching the VMAs. If nothing else, the inconsistencies should have been run to ground before Mr. Buzbee sponsored allegations that cannot withstand a simple Google search. They say sanctions are warranted. These factual discrepancies are neither isolated nor surprising. They result from Mr. Buzbee's rush to launch allegations unhindered by mandatory diligence. Mr. Buzbee's claim of rigorous investigation does not square with the known facts, including how a single initial media interview turned up glaring problems that counsel had either ignored or never investigated. Indeed, Mr. Buzbee does not even claim that he did anything to investigate the allegations before signing his name to them. That conceded failure is sanctionable under Rule 11. As for the role played by unspecified lawyers at Ava Law, who first investigated plaintiff's claims and drafted the complaint, and by 2 unspecified non-declarant lawyers at Mr. Buzbee's firm who purportedly interviewed plaintiff pre-filing, there is no claim that they corroborated anything in the FAC, nor is there any explanation for why they never contacted plaintiff's father and missed such obvious discrepancies. Everybody failed. To make matters worse, I said everybody failed. You know what I'm saying? Just so y'all know, I didn't read that. That's me. To make matters worse, Mr. Buzbee refused to withdraw any of the allegations even after NBC exposed the ostensible falsehoods. Finally, it is telling that Mr. Buzbee never sought requisite admission to this court before being so ordered. Mr. Buzbee implies that he may freely practice law in this district without applying for admission to the court's bar, or pro hac vice. In the more than 3 months since he filed this case, as well as throughout other cases in this court, but an attorney must be admitted before signing pleadings or appearing. Although Mr. Buzbee submits he is not aware of any requirement that he seeks interim pro hac vice admission while his application is pending, he has not identified any pending application. Such disregard is emblematic of his broader non-compliance. Plaintiff is not entitled to attorney's fees. Mr. Buzbee tries to turn the tables by seeking fees of his own, but has no colorable basis for them. The motion has ample good faith basis and is not clearly frivolous, filed for an improper purpose, or not well grounded in fact or law. Mr. Carter identified numerous factual allegations that are demonstrably false, see Supra IA, and sought only to vindicate Rule 11, not harass, cause unnecessary delay, or needlessly increase the cost of litigation. None of plaintiff's authorities properly read points to the contrary. Conclusion: the court should impose Rule 11C sanctions and direct the parties to confer on a schedule for briefing and award. So they saying, just give me my money. Certificate of word count compliance. I, Alex Spiro, an attorney duly admitted to practice before this court, hereby certify pursuant to Local Civil Rule 7.1 and Rule 3D of Judge Annalisa Torres, individual practices in civil cases, that the annexed memorandum of law was prepared using Microsoft Word, and the document contains 3,471 words, and we don't need to know all that shit. Okay? So that's Alex Spiro responding directly to Tony Buzbee, who says he should not be sanctioned. He should not be charged. As a matter of fact, Jay-Z and his legal team should be paying him for inconveniencing the courts and wasting his time. They came out swinging nothing but haymakers in this motion here, or in this response. Good God. I gotta say, it's gotta be pretty obvious at this point that anybody that believes the original lawsuit, or what they are calling the amended complaint, if you believe that shit, you have no relationship with reality. I'm sorry. That's my opinion. Right? There's so many holes. It's just a fucking bag full of holes. Like, it's a water bottle full of holes. You try to fill that bitch up and it just comes draining down. It don't make no sense. So if you believe it, you willfully just want to see the downfall of Jay-Z and the continued downfall of Diddy, which I have no remorse for him, but all the evidence or all the information on this particular case indicates that neither one of them took part in this bullshit. You can hate Diddy with your entire heart. You could tap dance on that nigga's demise. Be my guest. But this shit here and a lot of the other shit that people are putting out there on that nigga's name, it ain't real. It ain't right. You know what I'm saying? I will never forgive that nigga for what he did to Cassie, though. And if she was subjected to unlawful, unwillful sex with escorts, which would be translated in a court of law as trafficking, I think he should go down for that. But if there's anything else that is being alleged that he did not do, I can't hold somebody accountable for some shit that they did not do. And you don't have any kind of demonstrable evidence to suggest that they did. Got to be honest, got to be real. And that's that. We've been talking about this for 3 months, almost 3 months now. It ain't the time for pulling punches, trying to sugarcoat no shit. Tony Buzbee has not brought anything substantial to the table except a bunch of accusations. Some Rick Ross accusations. And all of them are falling apart right in front of our eyes in a very short amount of time. Although it feels long as fuck because I'm tired of it. But y'all let me know what y'all think of this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I'll catch y'all on the next one, all right? Peace.
King of my city and cul-de-sac. Coming out swinging like soldier rag. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef on computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. With drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I've been dropping these haters like calories. First I'm out, I came back with some boundaries. Stand for my honor, but too raw, no corner. Packing the stick with a drummer. Wanna catch my bad, won't fumble. I done came too far to be humble.